Thank you, gentlemen.
Welcome. Good morning. We are at the 10 o'clock oral argument for the 5th District Court of Appeal here today, Thursday, March 25th. And I am Rand Wallace. I'll be presiding today. Joining me on this panel are Judge Jay Cohen from Orange County and Judge Jim Edwards from Seminole County. We have Osceola County Board of County Commissioners versus Sand Lake Surgery Center et al. Mr. Angel, I'm going to assume that you would like 5 minutes of rebuttal unless you tell me differently. And with that, you may begin.
Thank you, Your Honor. And good morning, everybody, and may it please the court. My name is Derek Angel. I represent Osceola County in this appeal from our denied motion for an order to show cause against a non-party Sand Lake Surgical Center. The underlying action is a straightforward premises liability injury case. The two plaintiffs alleged that they were traveling in a Osceola County courthouse parking garage elevator when the elevator allegedly fell from the 3rd to the 1st floor, causing them injuries. They've been represented by the same attorney with the Newland firm at all times and filed separate lawsuits, and then proceeded to receive medical treatment at the same facility. During routine pretrial discovery, we identified that provider, Sand Lake Surgical, among others, and served again a routine notice of non-party production, informing the plaintiffs that we would be seeking discovery from that entity. No objections were lodged, and again, that
counsel, we're very familiar with the facts and what's going on. Let me just make sure I'm totally clear. And Mr. Myers, of course, will keep a sharp ear, no doubt. Sand Lake Surgical never raised a trade secret argument below or on appeal. Is that correct, Mr. Angel?
That is my understanding. I think there were some sort of, I want to call them tertiary references that perhaps if we got into a deposition of the corporate representative, that maybe some questions about the methodologies and pricing schedules would be raised, and those would be trade secrets. But the arguments, as I understand what they've made as to the subpoena in particular,
right, we're not there yet. Yeah, I mean,
you
know, they haven't waived any potential trade secret things they may have in a deposition, but just in terms of the notice of non-party production, all they raised was we have a contract with AMF that says we can't tell you how much they paid us for these accounts receivable related to these patients, correct?
That is my understanding, and indeed, I believe their brief does say that they are not raising the arguments that were addressed by AMF in that hearing pertaining to trade secrets and also to relevance. So those issues were addressed by AMF, but not here, and I believe those have been effectively waived, seeing that AMF has not participated in this appeal.
Yeah, and there's no issue of relevance on appeal either, correct?
Not as I understand it, nor could there be. My understanding is the law is pretty clear that a non-party has no standing to object to relevance. That they can object, of course, to overbreadth or the violation of some sort of confidentiality clauses they have here. But relevance is an issue for the parties, not for non-parties to raise. And
right.
the plaintiffs.
So basically what it comes down to on appeal is there's a contract between Sand Lake and AMF, and Sand Lake doesn't want to violate it voluntarily, but they'll do whatever the court orders, is what I kept hearing below and reading in the brief. Am I missing anything there?
Your interpretation is the same as mine, Your Honor. That's exactly what I understand they're arguing.
All right.
Yes, sir, Your Honor.
Does a confidentiality agreement define what is or is not discoverable in terms of a provision between two contracting parties, not including Osceola County?
I think the law has been clear for a long time that a bona fide confidentiality clause cannot stand in the way of a party's legitimate need for discovery. And that's a bona fide confidentiality clause. I have my questions about the confidentiality clause here.
We have no idea what it is.
We don't know what the contract says. That's correct.
Okay, so I mean, the council's made reference, and we'll take it that they made them in good faith and that they were accurate. But of course, it's clear law that the unsworn statement of counsel is not a substitute for sworn testimony, correct?
That's correct.
What remedy do you think you're entitled to from this court?
I think that that's a straightforward answer, Your Honor, which is a reversal of the order on appeal with directions for Sand Lake Surgical to comply with every category of evidence that we sought in the subpoena.
Now, go ahead. You've answered my question, so you can go ahead and make your presentation as you wish now.
Thank you. And speaking to that confidentiality clause, since it came up, I know we have three very experienced jurists here understand the nuances of what's going on in these cases. But here we have, this is not a family physician who has been being engaged in litigation for the first time. We have a surgical center that signed a contract directly with the plaintiff's attorney. That's what an LOP, of course, is. And this case does have a letter of protection in it, which is one factual distinguishment between our case and the case 6 weeks ago from the second DCA, where there was references to an LOP, but apparently not a technical LOP in place. Now, I'm not sure I agree with everything in that case, the way it characterizes what went on and what the relationship with Biospine is in that case, but that's neither here nor there because we have an LOP in this case. So we have a sophisticated surgical center who knows what's going on in litigation, and then they sell this bill to a factoring company. And again, the nature of this company is to speculate on tort claims, as I argued in the brief, and frankly, AMF's lawyer gratuitously sort of described. And as I was preparing for this argument and reading back through that transcript, it dawned on me that it sounds a lot like Wall Street. I mean, they analyze these cases for how long they'll be in suit. Is liability contested or is it shaky if it's a slip and fall, for example, and even the quality of the attorneys goes into their factoring. So I think, and this is another thing that bothered me a little bit about that second DCA case from last month. We should be even more, I think, vigilant about discovery and admissibility in this arena than that case, I think, would suggest. We're talking about personal injury claims, and I think it's been the public policy of Florida since before there was Florida that you cannot assign personal injury actions. They're personal. In fact, I think that rule goes all the way back to England before there's the United States. I didn't research that, but I think it's that old.
Maintenance and champerty, right?
There you go. That's the champerty. That's the phrase I discovered about 6 months ago. So that's exactly right. But in this case, and of course, this is not unique to this case. This happens all the time. We have a factoring company, a purely profit motivated independent business entity that is purchasing one of the biggest deltas of damages, which is compensatory damages. To me, that's almost an end around on the champerty rule, right? So I think that we should be more open to discovery to figure out what's going on in these cases, to allow the jury to do its ultimate job, which is to assess damages reasonably caused by whatever the tort may be. Of course, that is the touchstone. It's not what the plaintiff decided to enter into a contract for, it's what damages were reasonably caused. If we get into a car wreck and a plaintiff travels to Beverly Hills for surgery that is available everywhere else for 10% of the cost, that wouldn't be a reasonably sustained damage. And I think these arguments were sort of made by AMF at that hearing. Of course, it's frankly surprised me AMF is not here with us. I did not expect that when I filed this case. But they discussed that these plaintiffs owe this amount of money regardless of what happens.
Mr. Angel, we could try to get him on the phone if you'd like.
I think I'd be happy to
I'd
throw
sure
that
be
offer.
for that, Judge.
Well, let me ask you this too, Mr. Angel. It seemed that the trial court got off a little bit on the Worley versus YMCA and the Bosher versus Allstate. That really doesn't have anything to do with this notice of non-production or production from non-party, does it?
No, and in fact, Worley could be bad law in 53 minutes here. We have our 11 o'clock weekly Supreme Court opinions. I don't know if anybody else watched that argument, but I know Justice Polson made no bones about where he's going with it. In any event, you're right.
And the other thing too that distinguishes your case from the more recent case out of our sister court, I guess is the word we always call. This was all the discovery here was limited to these two plaintiffs, wasn't it?
That's correct, and that as we know, facts matter, right? And that distinguishes us not only from that recent case, but from just about every other case. We look at Lake Worth Surgical from 2 years ago. The defendant there sought 3 years of scheduling and how many cases the surgical center takes from litigation versus non-litigation, and the court didn't deny that. The court, in fact, compelled it. The issue on appeal there was whether they needed to be a confidentiality clause. So it wasn't a matter of discoverability, it's just whether we have confidentiality. And in this case, Osceola's trial counsel offered, I think gratuitously, to enter into confidentiality with these discrete sales of these particular bills for these plaintiffs.
Right. In terms of the confidentiality agreement, the issue I saw was at the hearing, it seemed that Osceola had offered to enter into a confidentiality agreement with AMF, who declined or didn't get back, I guess is the more accurate statement. And Sand Lake has maintained all along that it is willing to enter into a reasonable confidentiality agreement. And for whatever reason, it just hasn't happened yet.
That's my understanding. Of course, the evidentiary record is limited because we're dealing with, as Your Honor noted, with comments of counsel. But regardless, whether or not AMF is willing to enter in confidentiality doesn't make a difference to us. So our confidentiality is with the party that we subpoenaed, who is Sand Lake. And the bottom line is they've refused to enter into that agreement. It's their.
Well, that's Mr. Angel. That's exactly what I was saying. I think it was AMF who didn't get back to Osceola's trial counsel, and that somehow Sand Lake and Osceola don't appear to have ever actually sat down and tried to hash one out. And Mr. Myers can speak to that if he wishes to, if it matters to anybody. But
yeah, I don't think it does matter. Ultimately, what we were seeking was for the court to compel the documents, right? And so if that's compelled, I don't see how they could ever be in breach of a contract where they're following a court order. Right? And I that goes to one of Your Honor's earlier questions, that a confidentiality clause cannot trump legitimate discovery. One thing I want to point out, Judge Cohen, you mentioned we could get Mr. Myers on the phone. Not Mr. Myers, the lawyer, Mr. Friedman.
I'm here.
The context of this hearing, and to speak to the Worley case being, I think, in the same ballpark, but on the opposite sides of the field as the issue that we have. This hearing was, looking back at the date, it was the day after Governor DeSantis closed all the restaurants. Right? This was, in hindsight, sort of COVID purgatory, right? We didn't have the Zoom, universe that we have now. And this hearing took place over the phone with 6 people on the phone. We had the judge, the court reporter, and 4 attorneys. And it's over a 45-minute hearing. That is just not the effective means for this sort of issue. And I think with a number of issues that were raised at this hearing, when you talk about all the HIPAA objections that were discussed, even though I don't see how HIPAA applies when we're dealing with all the medical records already been disclosed. And we had, they don't want to breach a contract. And we hear this relevance bit, and then we hear a trade secret argument that, frankly, I thought just got the law backwards. I think the Lake Worth case makes it very clear that a discrete sale is never a trade secret. And that was contrary to what AMF argued. I think it's easy to understand how the court over the phone hearing all this could have mixed this up with the Worley jurisprudence. And of course, Worley, as I read that case, for whatever it's worth right now, it really focused on attorney-client privilege. The concept there is that when a plaintiff lawyer recommends a provider to his or her client, that is privileged. And so are all the other references that they make 10 times a day, apparently over 10 years, is all privileged. So that, of course, has nothing to do with this case, as Your Honor mentioned. This has to do with the after-the-fact sale of that account receivable to a totally unrelated party.
And as far as HIPAA, all the plaintiff's medical records were produced and all the medical bills were produced, correct?
That is correct.
And the only documents that were withheld were relevant only to the transaction between Sand Lake and AMF, correct?
That is the representation by their counsel, yes. They've produced everything other than the after-the-fact sale and those related documents.
All right. All right. Well, thanks. You've addressed all my concerns, and you proceed as you wish, or we can go to Mr. Myers.
Yeah, I think I've touched on everything, and thank you, Judge Edwards, for directing me somewhat. Finally, I do want to, if there are questions, particularly about the court's jurisdiction, this case, Your Honors have seen exponentially, to say it, put it mildly, more cases than I have, but I've never had a case in this posture, which I filed as an appeal, was converted to certiorari, and then after that briefing process, back into an appeal. So there was at least some trepidation about appellate jurisdiction as opposed to certiorari jurisdiction, and I'm happy to answer any questions, but I think the court has ruled on that, and of course, I would stand on the briefs if there are no questions in that regard.
Yeah, and just for your benefit, Mr. Angel, we have a motions panel that addresses something originally, and then we have the merits panel, and it's not completely uncommon that the merits panel will take a different view of things than the motions panel did. It's not frequent, but it does happen. So, I wouldn't read too much into that.
I understand that. In fact, I've been on the good side of a reconsidered initial ruling before from this court. So I'm very familiar with that process. And that's why I took the time in my brief to spell out why I think it's clear that there is appellate jurisdiction in this case. And if there are questions about that, I'm happy to answer them. But seeing that that my colleague, Mr. Myers, did not raise anything in that regard in the answer brief, I'll just, like I said, stand on my briefs on that position. Okay. Thank you very much. I appreciate the court's time. Again, we would request a reversal as discussed earlier, and I will reserve the rest of my time for rebuttal.
Okay, Mr. Myers, you may proceed.
Good morning, Your Honors. I appreciate the opportunity to do this in a very unusual format. I've been at this for about 5 decades. This is a unique case in many respects, one that started as certiorari and then became an appeal. But it's unique for me. I've never been in a position where if I argue too long and too broadly, I might find myself arguing against the court that ruled in my favor at the trial level. And I appreciate that. I understand that. I've been candid in my briefs. I did make perhaps one error in referring to, as Mr. Angel pointed out, to the section 7.11, the confidentiality and non-disclosure provision that is not in the record. However, it was discussed profusely, if you will, in 5 different areas of the transcript, colloquially between the counsel and the court. So it was no secret that was the obstacle over which we could not get with respect to either a confidentiality agreement or in this case, we expected, as you might see from the transcript, I expected there would be an in-camera inspection of either the confidentiality section or the entire contract. So I was prepared to do that. As Mr. Angel pointed out, we were scheduled for an in-person hearing on 3/18 of 2020. So I had marked the documents as confidential. I had redacted the 32 of the 34 patients since, and Mr. Angel is correct, I've seen a number of these subpoenas from much more aggressive defense counsel asking for the moon with regard to financial information. This was very circumspect, very direct. We just want the information on these 2 patients. I think you're correct, Judge Edwards and Mr. Angel, or the transcript discloses that relevancy was settled. It was even admitted by AMF's counsel that the payment for these 2 injured patients at Sand Lake Surgery Center was indeed relevant. Now, he went on to some other arguments later on that suggested that you could never find the answer to the question posed by the appellant at the lower court hearing, and that is what was accepted in a payment for these 2 cases. In other words, we charge what we charge to everyone the same as we're required by law to do, and we are reimbursed by various factors, either fee schedules, some that are published, Medicare fee schedule, the workers' comp fee schedule is published. So everybody knows what we're going to get paid in those instances. In instances that involve commercial insurance, as I've argued, and I think Mr. Angel would admit this, if they represent insurance companies, their fee schedules are confidential. And we can't produce those any more than we could produce a confidential payment or a contract with a funding company, as in this case. But I wanted to point out that I was referring to the discussion about 7.1 confidentiality and non-disclosure. And when Judge Murphy asked me why I thought we would be violating our contract if we disclosed the payment information on page 30 of the transcript, or I'm sorry, page 28, I quoted directly word for word from that provision, which unfortunately was only before the court in a chamber copy, which it would have been if I'd handed it up in camera in an in-person hearing, but because of COVID, we couldn't do that. So I felt like that it was part of the record, part of the transcript, and I apologize if I violated a basic rule of referring to something that's outside the record. I think that discussion and the reading of that confidentiality provision, word for word, indicated that we couldn't disclose either the payment information, terms of the contract, or the contract itself. Now, as a practical matter, the contract has been disclosed. We've argued it. I had to invite Mr. Friedman to the hearing on 3/18 of 2020 because that was required. Unfortunately, he didn't make a notice of appearance. He never moved for a protective order. And if there is some concern with regard to the trial court being confused or misdirected, and with all due respect to the Worley reference, we'd be guessing at what Judge Murphy was thinking if we suggested that he was thinking of Worley. I think he made a comment about the position of the Florida Supreme Court, not so much how it is constructed or whether it's going to revisit any other particular case. I think, frankly, the judge was did not feel that we were in a typical protective order hearing stance. There was no motion for protective order. This was a motion by the defendant for a rule to show cause while my client shouldn't be held in contempt for failing to provide information it believed to be confidential.
Well, Mr. Myers, let me interrupt you here for just a minute.
Yes,
when I was talking with Mr. Angel, I could see you often nodding your head in agreement, but I just want to be sure we're all there. Relevance is not an issue. Trade secrets are not an issue. Do you agree?
Yes, Your Honor, I do. And standing was not an issue, according to the judge.
Right. And the only issue is your client does not want to violate its contract, which apparently would have financial consequences to your client if it revealed voluntarily the information requested by Mr. Angel's client, correct?
Yes, yes, sir. Yes, Your Honor.
And you've said all along that you would abide by the order of the trial court and whatever this court tells the trial court to do. Is that correct?
Yes, Your Honor.
And do you know of any legal basis for not granting the relief Mr. Angel said he believes that his client is entitled to?
Well, with all due respect, if the court finds that the balancing test, and by the way, you don't have a real well-defined transcript showing a balancing test because the appellant said we don't want a balancing test. That was the
I was concerned about that, but when I saw that in your brief, I thought perhaps they had waived something. But I went back and looked at what the transcript said. And basically, it was that Osceola County had offered to enter into a confidentiality agreement with AMF so that it would not have to have the trial court do the balancing test and look at everything. And so I don't really take that as they told the trial court not to do a balancing test. I think they were trying to avoid that. But let me ask you this. What proof of confidentiality was there other than a reference to a contract not in evidence?
Candidly, Your Honor, there was none in the transcript. However, with regard to confidentiality, and again, with all due respect to Mr. Angel's request for reversal, if the court finds that the record is insufficient with regard to the balancing test and the trade secret information either being not properly weighed, I think the remedy would be remand rather than reversal. So
you think y'all ought to get 2 shots at proving confidentiality and trade secret when you didn't take advantage of it before?
We're not taking a shot. Unfortunately, we're left holding the bag here because we only have a confidentiality issue. They, that is AMF, the funding company, are the ones that have the trade secret issue. And frankly,
I totally understand that. I understand you're in, as you started out, you're in a very unusual position and you can't do anything voluntarily on behalf of your client to violate the confidentiality agreement, but AMF did not provide any information of confidentiality, any evidence of it, and did not provide any evidence that the information was trade secret during the hearing, and has chosen not to participate in this appeal. So what we're left with in this appeal is a surgical center who has produced what it can and has stopped short of producing what would violate a contract. But the party who really apparently cares about the confidentiality of the information has chosen not to participate in the appeal. So it's kind of, I've been scratching my head, you know, kind of what are we doing here?
Well, I've been scratching mine too, and I've lost some hair in doing it because I'm, you know, I have successfully, unfortunately, this is a unique position again. We avoided an order to show cause why we shouldn't be held in contempt and converted ourselves from a non-party medical provider witness into a party on this appeal. And it's like we've gone from the frying pan to the fire. And unfortunately, I'm kind of carrying the water, so to speak, of upholding the court's interpretation of AMF's trade secret and privacy argument, because at the end of the day, that's all the court said in terms of prefacing its ruling in upholding our objection and the objection of AMF based on its privacy rights. Now, again,
Right. Well, the trial court didn't want to hold your client in contempt of court based on your client's desire not to violate a contract. And I don't really think anybody's that interested in holding your client in contempt of court. They want the information, and
sure,
you don't really care if they get it, other than you don't want to violate your contract.
but all I really need is a protective order from the court, or an order of confidentiality from the court. Now, if you look at the transcript, even AMF's counsel at page 47 indicated it would work to negotiate a confidentiality agreement.
If it had to.
If it had to, I understand. I mean, it was basically taking advantage of our position and carrying its water for the protection of what it claims to be a trade secret. And as I've been candid both at the hearing and with my briefs, we weren't raising that. We feel, and I think everyone agrees, including the lower court, that the payment information is relevant. Now, whether or not the contract is, I would submit that that's a different issue. But nevertheless, I think that reason. Now, the court in the second district, which is over in near my hometown here, Lakeland and Tampa, has issued its opinion in the Biospine or Gulf Coast Spine Institute and Biospine Institute. The reason I joined Mr. Angel in his supplemental authority submission is that case, it references, it at least indicates, and your court is in the Winn-Dixie versus Miles case, indicated that some substantial weight should be given to a provider, a medical provider, non-witness that didn't choose to be in the litigation. And that's us. I don't think we're any more sophisticated than Biospine, which does an awful lot of brain and spine surgery at Gulf Coast. So I don't think that can't really distinguish that case. But I think they referenced there that and I don't think reasonable necessity was ever addressed in the lower court, as was not the balancing test in terms of what the court would normally the steps that would normally be taken.
Mr. Myers, you don't get to a balancing test until somebody actually makes some proposition that it's confidential information with some evidence, or that it's trade secret with some evidence.
And again, an argument of counsel. I'm sorry, Your Honor.
Yeah, and not that we can exactly force you guys to agree to a confidentiality order, but that really seems to me to be more than anything else what this whole appeal is about. If the information were limited to this litigation and not disclosed or disseminated outside the litigation, it seems to me that you, AMF, and Osceola County would all just be happy as clams at high tide.
Judge Edwards, you basically made my closing argument. That's exactly the way I've approached this since the beginning. And frankly, again, with all due respect to Mr. Angel, the reason I've cited HIPAA is that what you just quoted is the HIPAA regulation that I provided to the lower court and have cited in my briefs, and that is 164.512E as an echo, and then it's a small Roman numeral 4 and small Roman numeral 5, subsections A as in alpha, B as in Bravo, and those sections say just what Judge Edwards indicated, that if there is a confidentiality agreement among the parties or an order to disclose what is alleged to be trade secret, then the information stays in the case at bar and is either destroyed or returned at the close of that case. I tried, and again with Mr. Angel's trial counsel, Mr. Tessitore, and I tried to persuade AMF to enter into a voluntary confidentiality agreement. I think with their admission on page 27 of the transcript, perhaps that's what the court should have done. Apparently, after, and by the way, Judge Murphy did offer, after I recited that I had been prepared to provide the contract in camera with the exhibit and the redacted 32 patients, and you've got the 2 patients that they've asked the information for, what the charges were, the bulk purchase. All you got to do is simple mathematics, and you could figure out what the percentage adjustment was. That was offered by Judge Murphy to AMS counsel, and AMS counsel said no, because if somebody finds out what we paid for this, the rest of the world of medical funding companies, that's in the transcript, would know what we are paying. Well, that's not true. Unfortunately, I mean, I'm again in between a rock and a hard spot. I can't argue against my contract partner and say, wait a minute, if it's disclosed by under a court order and a confidentiality provision, then nobody's going to know about it outside of this case. But again, I feel like I'm arguing with one hand tied behind my back in terms of trying to honor the contract provisions and prevent my client from suffering damages, and still trying to comply with the subpoena where I think the information, and everyone, I think all the case law is clear, is the information is relevant.
Well, Mr. Myers, we'll try our best to help you out of that Gordian knot.
Well described. I'd appreciate the help, Judge. I don't know how it's going to happen, but I do appreciate the time accorded me to defend the court in Osceola County and my client's actions, which have been, I think, consistent with a Herculean effort to comply with the subpoena and do the right thing without getting in trouble with the funding company. Unfortunately, we have to do these things because we can't wait on a lot of these treatments to get paid, and we got to keep the doors open to treat injured patients.
I mean, you can't get your employees to wait 5 years to get a paycheck?
No, Your Honor, that doesn't work even outside of a COVID pandemic. And again, I just think that this is a very unusual situation. As Mr. Angel said, a lot of issues were discussed on a phone conference that was really generated a few days before an in-person hearing was to be had. And
Mr. Myers, I think your position in your presentation to the trial court, your briefs and your oral arguments, crystal clear where you stand, and we certainly appreciate your candor.
Thank you, Your Honor.
Angel.
You have to unmute because we're working on reading lips, but we haven't perfected it yet.
Thank you for it. Also warns me, so I appreciate that.
Okay.
A few points. AMF, I think the parties here would be happy as clams at high tide if we had a confidentiality order. But
are clams really happy at high tide?
they open up, I think, and I don't know. Barnacles.
Have you ever heard one complain?
No.
I don't think they would be happy. I think that they were fighting for whatever reason to keep this private. I think they're afraid of what might be found. I'm surprised they're not here. But they also, and I'm sure Mr. Myers just just misremembered this, but they did argue against relevance quite strongly at this hearing. They said, right here on page 267 of the record, but I don't think this court should order a disclosure because the information is not relevant and will not lead to relevant or admissible evidence. So they were fighting tooth and nail to keep this.
Right, they agreed to the relevance of what had already been produced, period.
That's my interpretation. Also, as far as Judge Murphy's comments, I don't really think it is that speculative what he's referring to. I think it's pretty clear it was Worley. In a few lines here on page 283 of the record, he specifically references, there's been a change in the Florida Supreme Court. I really believe that all of this stuff is eventually going to be stuff that the Board of County Commissioners will be able to get. But the status of the law, as I understand it now, is that the Board of County Commissioners is not entitled to that information now. That is, in my view, a sort of paradigmatic example of someone who is not exercising discretion within a threshold of a grayscale, but feeling compelled to act one way or another, which is why I've argued that this should be a de novo sort of review case. Finally, as to the balancing test and what we're supposed to do, the first step of that balancing test, and Judge Edwards, you were hitting on this, is that there first must be a showing that what's being sought is a trade secret. That's step number one. Only once that has been met do we move to the second step, which is to consider the interests of the requesting party. And in this case, as we've established now, I think crystal clear, is that there is no trade secret consideration in the first place with as far as the medical or the surgical center goes. So that whole balancing test analysis doesn't even apply.
Let me kind of jump ahead a little. Given the posture of this case, do we have any authority, if we desired to on remand say, and by the way, include a confidentiality order or agreement, or are we limited to simply remanding at this point?
I think if we were to look at what happened in Lake Worth and also in the Biospine case from last month, all of those cases, including the other Gulf Coast case from 8 years ago, that was a different Gulf Coast facility. They all basically said, Judge, you didn't follow these steps, go do it in the first instance. In this case, I think we've established there is no trade secret. So I think we could order, if the court were so inclined, to reverse and say, no, all this must be disclosed. Absent a confidentiality or in light of the concession that there are no trade secrets in this case. I don't think there's anything jurisprudentially wrong with the court ordering that on remand. If there's, again.
But you would have no issue with the inclusion of a provision that suggested a confidentiality clause, and I don't think Mr. Myers would either. Is that right?
That's correct. And of course,
That's correct. You're right.
Our trial counsel did, of course, offer to enter into a confidentiality clause to the trial court, so that would be consistent for sure.
Right. Okay. So if somehow we suggested that, neither one of y'all would move for rehearing on that particular point.
I can't promise, but probably.
Not Sand Lake, Your Honor.
That's fine. That's fine.
So,
I don't want to get a dissent on that either. So we'll see.
I cannot speak for your colleagues, Your Honor. So
Okay.
well, I'm running short of time here. I think we've touched on everything. I certainly appreciate the conversation and the discussion. Thank you again for the time, and we look forward to the disposition.
Thank you, counsel.
Thank you, counsel. Case was well argued, and we are adjourned.